Welcome to our webinar, The End of the Line, the options for the commercial lender when the workout is no longer working out. Today's webinar will be presented by Joe Vargas, who is a shareholder in Buckhalter's Real Estate Group, also Julian Goulet, a shareholder in Buckhalter's Insolvency Group, and me, Robert Wilner. I'm a shareholder in the firm's Commercial Finance Group. In today's webinar, we are going to discuss the ultimate remedies available for a secured commercial lender when the loan transaction has gone irretrievably south. Specifically, we're going to cover the following 6 options. Number 1, sale of the paper. Number 2, Article 9 foreclosures, both public and private. Number 3, strict foreclosures, either for full or partial satisfaction of the debt. Real estate foreclosures, both judicial and non-judicial. Assignments for the benefit of creditors. And finally, we will discuss bankruptcy options, specifically a prepackaged 363 sale. Well, let's dive right into the first option, the sale of the paper. So the beauty of this approach is that it is fast. Generally just the time that you need to draft and negotiate a loan purchase agreement, sign it, the buyer writes you a check, and now the loan is somebody else's problem. The disadvantage is that the buyer will expect a discount. Turning next to Article 9 dispositions. First, to public dispositions. The disadvantage of a public disposition is that it's essentially an auction, and this will generally yield the lowest net proceeds to the secured party. The foreclosing secured party is going to need to hire an experienced auctioneer, which is an added expense. And if the collateral is located on leased premises, most landlords, especially sophisticated or institutional landlords, typically do not permit auctions on site. So the foreclosing secured party will need to move the collateral to a warehouse or some other site in order to conclude the auction. And the cost of moving is an additional expense, and the value of the equipment is often reduced over what could be obtained if left in place. The primary advantage of a public disposition is that the secured party may be the buyer. Turning next to private dispositions. The primary disadvantage is that the secured party may not purchase the collateral if it is a kind customarily sold on a recognized market or the subject of widely distributed price quotations. I'm sorry, what I meant to say is may not purchase unless the collateral is subject to widely distributed price quotations. For example, stock of a public company that's listed on a national stock exchange. The primary advantages of a private disposition are that a sale to a strategic buyer will generally result in a higher price, and the foreclosing secured party can avoid the expense of an auctioneer. Let's talk about procedures. So every aspect of an Article 9 disposition must be commercially reasonable, including the method, manner, time, place, and all other terms. Let's talk about notice. So the UCC uses the term notification date, which is defined as the earlier of the date the foreclosing secured party sends an authenticated notice of disposition to the debtor and any secondary obligor, or the date the debtor and any secondary obligor waive notice. Who must receive notice of the sale? Well, The UCC requires the authenticated notice to be sent to number one, the debtor, number two, any secondary obligor, number three, any other person who before the notification date has sent the secured party an authenticated notice of a claim of an interest in the collateral. Fourth, any other secured party who 10 days before the notification date held a security interest in the collateral perfected by filing a financing statement. And lastly, any other secured party who 10 days before the notification date held a security interest in the collateral perfected by compliance with a statute, regulation, or treaty. For example, many states have landlord or warehouseman's liens and the like. Those parties must receive notice as well. The UCC, however, does not require notice if the collateral is perishable or threatens to decline speedily in value, or is a type customarily sold on a recognized market. Now, how can the foreclosing secured party be sure that it is sending a notice to everyone who's required to receive a notice because they have filed a financing statement? Well, the UCC provides a safe harbor, which says that notice to all parties who I've listed in 3B Romanet 2.4 above, in other words, secured parties who are entitled to notice because they filed a financing statement against the debtor listing the collateral. Notice to those parties will be deemed given if the secured party requests the UCC lien search between 10 to 30 days prior to the notification date, and prior to the notification date, the secured party either did not receive the search or received the search and sent a notice of disposition to each secured party listed on the search whose financing statement included the collateral. The UCC also has requirements for timeliness of notice, which the UCC specifies must be a reasonable period of time prior to the sale, but it also has a safe harbor which says that if you send the notice at least 10 days before the disposition, that will deem to be reasonable time. What should the notice include? According to the UCC, the notice of sale will be sufficient if it includes the following. Number one, names of the debtor and secured party. Number two, a description of the collateral. Number three, the method of disposition, whether public or private. Number four, a statement that the debtor is entitled to an accounting and the charge, if any, for an accounting. And fifth, the time and place of the sale. The UCC also sets forth a waterfall for application of the proceeds from the sale to be applied in the following order. First, to the foreclosing secured party's expenses of sale. Second, to satisfaction of the foreclosing secured party's secured debt. Third, satisfaction of debt secured by a subordinate lien if the junior secured party has sent a demand for proceeds to the foreclosing secured party prior to the distribution, and the subordinate lien is senior to the interest of any consignor that may have an interest in the collateral. Fourth, to any such consignor, if the foreclosing secured party receives a demand for proceeds prior to the distribution. Next, unless the secured party is required to pay proceeds to a consignor, the debtor is entitled to any surplus from the sale, and the debtor is liable for any deficiency. However, if the underlying transaction is a factoring transaction or otherwise a sale of accounts, chattel paper, payment intangibles, or promissory notes, then there is no surplus or deficiency. What does the purchaser get? Well, the buyer at a disposition acquires all of the debtor's rights in the collateral, free of the security interest of the foreclosing secured party, and free of any subordinate security interest. And A good faith purchaser is not at risk if the secured party has failed to comply with Article 9 requirements. Next, I want to talk about strict foreclosures, in the code referred to as an acceptance of collateral, and it can be for either full or partial satisfaction of the debt. What's required? Well, number one, the debtor must consent, but if the secured party sends the debtor a proposal for an acceptance of collateral, and the debtor fails to object within 20 days after the secured party sends an unconditional proposal, then the debtor's consent will be deemed to have been given. And the secured party must not have received, within 20 days after the proposal was sent, an objection from any person to which the secured party is required to send a notice of proposal, or any other person other than the debtor holding a subordinate security interest in the collateral. So who do we have to send the notice to? We need to send the notice of the proposal to any person who, before the debtor's consent, has sent the secured party an authenticated notice of a claim of an interest in the collateral, any other secured party who 10 days before the debtor's consent held a security interest in the collateral perfected by filing a financing statement. Third, any other secured party who 10 days before the debtor's consent held a security interest in the collateral perfected by compliance with a statute, regulation, or treaty. And lastly, to any other any secondary obligor, only if the acceptance is for partial satisfaction. So what you should notice is that the parties who are entitled to notice of the proposal are nearly the same as the parties who are required to receive notice of an Article 9 foreclosure action. But unlike an Article 9 foreclosure, in an acceptance of collateral, there is no safe harbor. The secured party assumes the risk of the filing office's delays and errors. Why is that? Well, because that unlike in a foreclosure action, in an acceptance of collateral, the purchase price is typically negotiated between the debtor and the secured party. And if there is a subordinate debt behind the foreclosing, secured subordinate debt behind the secured party's debt, then the debtor may be disinclined to object to the acceptance of collateral. For this reason, there is no safe harbor. So what is the effect of an acceptance? Well, it discharges the debtor's obligation to the extent of the debtor's consent. It transfers to the secured party all of the debtor's rights in the collateral. It discharges the secured party's security interest in the collateral and any subordinate security interest, and any other subordinate interest in the collateral, even if the secured party fails to comply with Article 9 requirements. So why would a secured party elect to do a strict foreclosure as opposed to a regular foreclosure? Well, it may be because that the market for the particular collateral is depressed at the time, and the foreclosing secured party believes that if it takes the collateral today and holds on to it, that at some time in the future, the market may come back and it may get a better price at that time. That those might be the reasons. One reason why a secured party may decide to take an acceptance as opposed to foreclosing and being done with it. Next, I want to talk about the right to redeem. The debtor and any secondary obligor or any other secured party or lien holder may redeem the collateral by paying the secured debt in full and all of the secured party's expenses and attorney's fees. But this must happen prior to the time that the secured party has disposed of the collateral or accepted the collateral in full or partial satisfaction of the debt. And finally, I want to talk about waivers, that the debtor is allowed to waive the notice requirements and debt redemption rights, but only after an event of default. It does no good to try to bake a pre-default waiver into the loan documents. That will not be enforceable. So at this time, I want to turn the microphone over to my partner, Joe Vargas, who's going to speak about real estate foreclosures.
Thanks, Robert. When it comes to liquidating real estate collateral, there are a few major avenues to explore. The first and perhaps most common remedy used when it is available is non-judicial foreclosure, also sometimes called a trustee sale. Second, there's judicial foreclosure, which is a process involving the filing of a foreclosure-related lawsuit. Third, we have deeds in lieu of foreclosure, which is roughly the real estate equivalent of the UCC Article 9 strict foreclosure that Robert just spoke about. And then finally, we'll touch a little on enforcing assignment of leases and rents, which is typically a very important source of funds when liquidating real estate. Before having any discussion regarding remedies against real estate, a secured creditor is wise to consider any special limitations that may exist under law that pertain to loans secured by real property. Many of these restrictions are statutory, but they may also arise out of common law. While, as Robert just covered, the UCC remedies are fairly uniform nationwide, remedies against real estate are generally governed by specific statutory frameworks that vary widely jurisdiction to jurisdiction. Today, I'm going to briefly touch on two of the major ones that exist in California, but that also may exist in various forms in one state or another. The first is California's One Action Rule, which is codified in California's Code of Civil Procedure 726A. It reads in pertinent part that there can be but one form of action for the recovery of any debt or the enforcement of any right secured by a mortgage upon real property. Now, the practical effect of this rule is that it limits the ability of a creditor to ignore its real estate security and sue on the underlying debt or pursue non-collateral assets of the debtor. Under California law, there is recognized the security first aspect of the rule, which requires a creditor to seek recourse on the security first. In addition, the rule limits a creditor's ability to take action on the debt and against other non-pledged assets of the debtor. However, the rule does not prohibit a creditor from taking action on other security for a loan such as UCC collateral. The rule is quite complex. It's often misunderstood. There are various exceptions that can apply and many variations in how the rules apply under a given circumstance. With that in mind, let's move on to the anti-deficiency rule. Anti-deficiency rules function to prohibit a secured party from obtaining a judgment against the debtor for a deficiency. A deficiency is the unpaid balance of the loan after the real property has been sold at a foreclosure sale. The specific details of anti-deficiency legislation vary from state to state. However, for purposes of today's presentation, I simply wanted to note to you that the primary anti-deficiency rule that affects most commercial lenders in California is the one codified in 580D of the California Code of Civil Procedure. The rule prohibits a creditor from obtaining a deficiency judgment against the debtor after holding a non-judicial foreclosure sale. It's worth noting that the anti-deficiency rule that exists in California does not prohibit actions against unsecured guarantors, provided appropriate waivers are obtained. Let's move on to a quick note on some residential considerations. In the event that a secured party's real estate collateral consists of residential real estate, particularly owner-occupied residential real estate, there may be additional procedural hurdles that one must follow prior to exercising remedies on the real estate. The primary effect of many of these rules is to give the debtor more time prior to a sale being consummated. Let's talk about perhaps the most common type of remedy that exists with real estate, which is the non-judicial foreclosure, or sometimes known as a trustee sale. A trustee sale is a private sale of real property, not requiring a judicial process. Please be aware that a non-judicial foreclosure process, while available and quite popular in California, is not always available in every jurisdiction, as some jurisdictions will only permit a judicial foreclosure to occur pursuant to a judicial process. A non-judicial foreclosure can have many advantages for a secured creditor. First and foremost, it does not require the filing of a lawsuit, as it is a process that's completely absent of any court interference. Because of the lack of judicial proceedings, non-judicial foreclosures are generally faster and far less expensive than judicial foreclosure actions. Another advantage is that a lender can hold multiple sales to the extent there's multiple properties securing the loan in order to maximize its sale price in the best manner that it deems possible. This is in contrast to judicial foreclosure, where all of the real estate collateral must be combined in a single action. Because of the flexibility, the lack of judicial constraint, the lack of any debtor redemption rights, a non-judicial foreclosure action often results in a higher sale price for the creditor. Let's talk about the disadvantages. In California, there really is one major drawback to non-judicial foreclosures, and that is that if you hold a non-judicial foreclosure sale, there's the unavailability of a deficiency judgment against the debtor. Now, as mentioned previously, this does not prevent a creditor from seeking recourse against its other collateral or against other unsecured debtors, such as guarantors, again, provided the appropriate waivers are obtained. Let's talk about judicial foreclosure. Judicial foreclosure is a remedy that's not often used in California, at least in comparison to non-judicial foreclosure. As I mentioned, some jurisdictions do not permit a non-judicial remedy, and in those states, judicial foreclosure may be a creditor's only option. For purposes of today's discussion, I will address the California advantages and disadvantages of judicial foreclosure. These pros and cons can vary from state to state, of course. As mentioned previously, a judicial foreclosure action is where a creditor requests a court order to sell a property to satisfy a debt. It's commenced by the filing of a lawsuit. The lawsuit often includes other causes of action besides the foreclosure, but nonetheless, the foreclosure proceeding is a judicial process, much like any other litigation a creditor may be involved in with its debtor. Advantages. First and foremost, in California, a creditor who forecloses judicially has the ability to obtain a deficiency judgment after the consummation of the foreclosure sale. This is in contrast to non-judicial foreclosures where a deficiency judgment is not available. Judicial foreclosure actions are also often conveniently used, or they're added on to court filings where the creditor might be seeking an appointment of a receiver, so that in that respect, the foreclosure cause of action can be appended to a court filing seeking other relief. Just because you commence a judicial foreclosure action does not mean you need to consummate it. You could be pursuing both non-judicial and judicial simultaneously and eventually just pick one or the other. Another reason some lenders choose judicial foreclosure may be the desire to file a lawsuit in order to resolve other disputed issues with the debtor, perhaps third parties. And filing the lawsuit as opposed to pursuing non-judicially may be a way to go ahead and resolve all of those things together. Disadvantages of judicial foreclosure. Primary disadvantage of judicial foreclosure is the fact that there's a redemption period in California, which varies somewhere between 3 and 12 months, depending on whether the proceeds from the sale satisfied the debt in full or not. If it's satisfied in full, it's 3 months. If not, the redemption period is 12 months. The redemption period allows the debtor to maintain possession of the property and possibly redeem the property, which means buy it back, for a sale price equal to the winning bidder at the auction. So the redemption right, the mere existence of the redemption right often tends to result in a lower sale price at judicial foreclosure sales. Because the redemption right essentially is a clout on title to the real estate. Let's move on to a rarely used but often considered option. The option I'm speaking about is deeds in lieu of foreclosure. A deed in lieu of foreclosure is quite similar to the UCC strict foreclosure discussed a few minutes ago by Robert. It's simply the concept of a debtor turning over and transferring the real property to the secured creditor in exchange for debt forgiveness. Generally, when these are considered, a debtor expects to obtain full debt forgiveness, but that's not always the case, and the terms of these will vary in each circumstance. There are some concerns with the validity and enforceability of these transactions. The primary reason cited for these concerns is the potential for an after-the-fact challenge by a debtor who claims that it was not able to avail itself of all of its rights and protections that are built in to the statutory foreclosure laws. So the viability of these depend on the facts and circumstance of your transaction. Generally speaking, they are enforceable if done properly, but it's worth considering a specific jurisdiction's approach to these prior to spending time and expense attempting to consummate one of these. The main reason why secured parties consider these transactions is speed. Rather than having to follow a strict foreclosure regime with the various notices and publishing requirements and corresponding waiting periods that would no doubt apply, a creditor can seek to have a property transferred fairly quickly once the documentation is prepared and clear title can be obtained. The major disadvantage to deed in lieu transactions is that the title taken by the creditor is subject to existing encumbrances on title, including all encumbrances that are subordinate to that very creditor's mortgage. This is in complete contrast to a foreclosure action, which, when consummated, wipes out junior interest as a matter of law. With all of the foregoing in mind, if a creditor still wants to pursue a deed in lieu transaction, there are a few key tips that one should always follow. First, the creditor must not release its mortgage on the real estate collateral. The mortgage should remain on title until the property is finally liquidated or sold to a third party. The reason for this is that in the event that the deed in lieu is later challenged or found to be invalid, a creditor can always resort to foreclosing under its underlying mortgage, which still remains on the property. Second, if you take title to a property pursuant to a deed in lieu foreclosure, you should use a single purpose entity. This avoids any merger issues, and it also protects the lender from owner liability concerns. Finally, you should obtain title insurance to ensure the interest that the creditor obtains at the time of the transfer. Let's move on to the last real estate remedy and briefly discuss enforcing assignment of leases and rents. The primary manner in which most creditors enforce an assignment of rents clause in a mortgage is through the appointment of a receiver, which is a court-appointed custodian for the property. Receiver is appointed by court action, primarily in order to enforce the assignment of rents provisions, although a receiver may have other functions as well. During the receivership, the receiver collects rents, maintains the property pursuant to the terms of the receivership order issued by the court. Another option is what we call obtaining possession of the rents. It's rarely utilized, and I have found that more often a creditor will simply make written demand upon the tenants, instructing the tenants to make the rental payments directly to the creditors. Generally, a creditor will have this right baked into its loan documents that are signed at closing. Furthermore, if there is direct contractual privity with a tenant pursuant to a subordination or an SNDA type agreement, it's often the case that the SNDA itself will provide that the tenant will agree to send the rent to the creditor upon notice from the creditor. Finally, making demand upon the debtor itself. If To the extent that rents have improperly fallen into the hands of the debtor, the creditor can go ahead and make written demand on the debtor to go ahead and turn those over to the creditor. One last area I want to cover before we move on to bankruptcy matters are some mixed collateral concerns. This is, of course, when a creditor has a combination of both real and personal property securing a single credit facility. Generally, there are two primary liquidation approaches when dealing with mixed collateral. The first is holding separate sales. The creditor proceeds against its UCC collateral in accordance with the UCC rules, and then forecloses on the real property collateral in accordance with its real property rules. Separate rules apply to each. The second main approach involves what's called a unified sale. As the name sounds, in a unified sale, the creditor would include the UCC collateral with the real property and sell the assets collectively. Under this circumstance, the real property rules apply, although there are some exceptions. Unified sales are generally possible when the personal property and real property are closely related to one another. Examples would be a hotel or a car wash, where the personal T is integrated into the real estate in some fashion. Now I will go ahead and turn it over to Julian, who will discuss bankruptcy-related.
Great. Thank you, Joe. So as Joe mentioned, I'm going to cover two related topics. First will be assignments for the benefit of creditors, and then after that, I'll spend some time talking about Section 363 sales under the Bankruptcy Code. So first, assignments for the benefit of creditors, a process known pretty much universally as ABCs or ABC sales. ABCs are essentially a liquidation proceeding that's an alternative to a Chapter 7 liquidation under the Bankruptcy Code and provides stakeholders, including, importantly, the secured lender, with an increased level of control over the process. Importantly, as opposed to Chapter 7 of the Bankruptcy Code, ABCs are a state law proceeding. So in the jurisdictions where it's available, you are operating under the different state laws rather than a single federal statute. California, which will be the focus of this overview of ABCs, is one of the jurisdictions with the most well-developed ABC statute and authority. And notably, as a side note, stakeholders in an ABC transaction, a liquidation anywhere in the United States, can avail themselves of the California ABC statute by contract, and we've seen that done a fair amount too, because the statute and the authority is so well developed out here. So quickly on ABCs, what are the advantages? First, ABCs are faster and likely less expensive than a Chapter 7 case under the Bankruptcy Code. An ABC sale can often be negotiated and consummated within a year, whereas many folks probably know a bankruptcy proceeding can last much, much longer than that. The second advantage for ABC sales, there is no court supervision, at least in California. Other jurisdictions, for example, New Jersey and others around the country, are much more court-controlled proceedings, but that's not the case in California. And that's one of the things that makes it an attractive venue for ABCs. And the fact that the process can be done out of court in California obviously has a large role in driving down the costs of the transaction and making sure that it can be executed efficiently and quickly. The third major advantage for ABC sales is that, as I alluded to before, the company and the secured lender, and if there are other stakeholders that have a say in the process, can select the liquidator for the assets. This is a level of control that is not available in Chapter 7 liquidation. In Chapter 7, the company files the bankruptcy petition, and the U.S. Trustee's Office selects a Chapter 7 trustee from the panel. of trustees available in the district, and the secured lender and other parties don't know whether that trustee is necessarily going to have the type and level of experience that you would want to oversee the liquidation or not. So importantly, the last advantage is, just to underline it, the lender can have a real influence in helping to select an experienced and qualified liquidator. Disadvantages of the process that we should consider. First, it's often more expensive than a consensual Article 9 foreclosure, as Robert noted a few minutes ago, which can be done much more quickly and likely more efficiently than even an ABC sale. So that's a consideration. Another disadvantage, and this is depending on how things play out, is that there is no court supervision. So that can be advantageous from a cost perspective and an efficiency perspective, but unlike a bankruptcy case that provides essentially a unified forum for all creditors to get into a single proceeding and litigate any issues with respect to the collateral and claims, an ABC, again in California, is out of court, and because that transaction is happening out of court, there's the risk that disgruntled stakeholders, other creditors, could run into court and contest the ABC, which could obviously be very disruptive and add to the expense and uncertainty of the transaction. Another disadvantage for ABC sales is that the buyer will not receive a court order approving the sale. So, as I'll discuss in a bit more detail in a few minutes with respect to Section 363 sales, in an ABC, there's no court blessing of the ABC. So if there are contested claims to the assets, the ABC transfer will not provide the same level of certainty as you would get in either a Section 363 sale under Chapter 7 or Chapter 11. And the last disadvantage for ABCs, from the borrower perspective more than anything else, is that the ABC does not really solve the insolvency problem for the borrower necessarily, unless it has its secured lender on board with the transaction. And that's because an ABC provides for, as I'll explain in a minute, the assignment of assets to be liquidated by a assignee, and that assignment can't be done free and clear of the secured lender's liens unless they're on board and consenting to the transaction. So how are ABCs handled procedurally? As I mentioned, the company / borrower selects a liquidator, which is an independent third party. There are, assignees and firms that specialize in this and specialize in different types of businesses that are being liquidated. So there is an ability to select one best suited for the transaction. The borrower and the assignee enter into a contract that provides for the borrower to transfer all of the assets, but none of the business's liabilities to the assignee. The assignee takes title to all of the assets. So it could be inventory, AR, everything available. At the same time, the borrower also provides the assignee with its list of creditors. And the borrower has to certify to the completeness and accuracy of that list of creditors and the amounts associated with each creditor's claim against the borrower. The liquidator, the assignee, provides notice to all creditors and solicits claims to be submitted. And at the same time, the assignee is trying to expeditiously and at the same time maximize value through the liquidation of the assets of the business so that it can then turn around and use the proceeds of that liquidation to pay all of the valid asserted claims against the borrower in accordance with the priority of those same claims under state law. The whole process, if things go well, can be completed within a year, which is a time frame that could be very attractive for an ABC transaction. So that is it procedurally and the discussion on ABC sales. Next, I'm going to turn to what we're terming prearranged Section 363 sales. These are called Section 363 sales because, of course, it's referring to Section 363 of the Bankruptcy Code, which authorizes the sale of assets by a bankrupt company's estate outside of the ordinary course of business. And Section 363 is a mechanism to sell those assets of the estate outside of a Chapter 11 plan, which is a much more lengthy process and far beyond what we're going to talk about today. Here we're talking about expeditious liquidations of assets of distressed businesses. So importantly for Section 363 sales, and why we're terming them prearranged 363 sales, the borrower and its lender can select the purchaser of the borrower's assets before the bankruptcy case is even filed. Here it's important to note that the greater the amount of work that can be done by the borrower, the potential purchaser, and the lender sort of overseeing the process, the greater amount of work that can be done on the purchase agreement and the sale more generally before the bankruptcy case is filed, the better, because once you are in Chapter 11, costs get really expensive and you start being in a proceeding, as we'll talk about in a minute, where it's a very high profile and visible forum, and parties can start to raise objections that can be disruptive to the process that the lender is trying to run. So as much as you can do before the filing, the better. I'd also make a quick note here that as the debtor and the lender are trying to identify potential purchasers of the assets, the purchasers and the interest that they are indicating to the borrower and its advisors as they're marketing the assets will shed some light on what route the transaction is going to take. If it'll become clear that maybe an ABC sale will do, and the parties will be able to take advantage of the efficiencies of that process, that's one route. If the purchasers see, for whatever reason, which we'll talk about in a minute, that there may be more uncertainty around the assets, or otherwise they would like a bankruptcy court sale order approving the transaction, then you'll end up in bankruptcy. So I'm going to talk a bit about some aspects of the prearranged 363 sale process now. As I mentioned before, the borrower and the lender can select the purchaser of the borrower's assets before filing the Chapter 11 case. Importantly, Section 3 sales for operating businesses especially are almost always subject to overbid in bankruptcy. The borrower and the purchaser can and should enter into a stalking horse purchase agreement before the Chapter 11 case is filed. That's what I was alluding to before in terms of as much of the negotiation and documentation as possible taking place before the case. That includes the APA. The APA will look a lot like a typical non-distressed purchase agreement, but will have some additional bankruptcy-specific provisions included. Some of those that come immediately to mind are provisions that the purchaser will insist on, including consent rights over what the Section 363 sale order will look like, and timing requirements also are a big item for the purchaser. Once the Chapter 11 case is filed, the borrower will ask the bankruptcy court to approve bid procedures that will govern the sale process and the auction. That bankruptcy court hearing and approval of the bid procedures will likely take place a few weeks into the case, and hopefully within that first month of the case. And throughout that first time period, the secured lender, in order to preserve the integrity of the process and make sure that it doesn't come into question later on in the sale, the secured lender and the borrower, who's now the debtor, will also be continuing to solicit interest through their investment banker, likely, in the assets, even while they're marching forward with the stalking horse toward a sale and an auction. Also, in the asset purchase agreement and under the bid procedures, the stalking horse purchaser will negotiate and very often get bid protections, including a breakup fee, expense reimbursement, and those are commonly approved, especially in the more frequently used jurisdictions in the country. So specific issues relevant to 363 sales on the next slide are secured lender credit bid rights in bankruptcy. This is worth noting for this program. because, of course, Section 363K of the Bankruptcy Code provides secured creditors with the right to credit bid their secured claims. So as an alternative, or in the absence of any third-party interest in the assets, the senior lender itself can act as a stalking horse and can credit bid its claim as part of that stalking horse bid. The secured lender has the ability to credit bid with respect to all of its collateral, and that credit bid is governed by substantive state law. So whatever the rights were of the secured lender outside of bankruptcy with respect to its collateral and ability to credit bid, those are preserved under Section 363K in the bankruptcy case. I'd also note that the secured lender's credit bid does not extend to unencumbered assets, and this is often an issue you'll see in Chapter 11 cases where there is not complete collateral coverage over the estate's assets. There might be some cash that's unencumbered or other unencumbered assets, often that are hard to value, and those are some of the more frequently litigated aspects of even expedited Section 363 sale cases. Another specific issue to bear in mind from the lender's perspective in 363 sales is that someone is going to have to pay the freight of the Section 363 sale in the Chapter 11 case, and often that is the senior secured lender who maybe is providing working capital to the debtor already or has a revolver. So lenders are the usual suspects when it comes time to negotiate funding for the case. That would be done through a DIP loan, debtor in possession financing loan, called a DIP loan, and pursuant to a DIP credit agreement. The debtor also would have to obtain approval for a 13-week operating budget. That would be baked into the DIP documentation. And if there's no need for additional DIP financing in the case, that budget would be baked into, at a minimum, the secured lender's approval rights with respect to the debtor's use of the lender's cash collateral during the Chapter 11 case. So one way or another, if the lender has an interest in the cash, they will have a right to a budget. And the budget will, just quickly, will include all of the ordinary course operating expenses of the debtor in Chapter 11, plus all the administrative costs that make the Chapter 11 case so expensive, including professional fees, U.S. trustee fees, committee fees, and the like. I'd also just note very quickly that the DIP is an opportunity for the lenders to maybe address some aspects of their secured position through the roll-up of pre-petition debt. Next slide. So the timeline for a Section 363 sale, ideally, and all cases are different, but a good rule of thumb is that you can accomplish it in 60 to 90 days if you have a stalking horse lined up before you file the case. Certainly, that can go longer. What things that can affect the timing? Litigation in the case, if you're fighting with a creditors committee over collateral, if you have other litigation that could upset things, and more recently now in various Section 363 sales, including essentially liquidation sales, you're seeing what are sort of referred to as COVID delays, where this is not the time to be liquidating a lot of these retail businesses, and that has affected the timing of these sales that were starting just as COVID was also ramping up and now have been delayed and delayed. Also on timeline, sale milestones. This is one of the primary ways that a lender can maintain control over the timing of the process. These will be baked into the DIP credit agreement and or the consent to use of cash collateral. And the milestones would include everything that the lender would want to see to make sure that the sale process is moving along on the timeline that they bargained for. It'll include the filing of the Chapter 11 case, the first day motions to keep the lights on at the business, the approval over DIP financing on an interim and final basis, the approval of the bid procedures, which we talked about, will hopefully take place within the first few weeks or month of the bankruptcy case, the deadline for bids, the auction date, the hearing date for the sale, and the closing to close out those milestones. And obviously, the lender in the Chapter 11 case maintains control over the process because those milestones would be keyed to events of default under the loan documents to the extent they're tripped. Also briefly, as I mentioned before, it's important to remember, even in these prearranged, expeditious Section 363 sales, there will be a market test. So the stocking horse credit bid is the highest and best bid that the debtor could obtain going into the Chapter 11 case, but it's going to be subject to overbid. And the estate, as I mentioned before, has an obligation to continue to market the assets to try to find a bid that would maximize value. And often, as I also mentioned, an investment banker is a key player in making sure that that's a process that does maximize value. Quickly, I'm going to run through advantages and disadvantages of a 363 process in court. So advantages. The bankruptcy court Section 363 sale order increases certainty and bidding. So because you get a sale order that makes it clear that the assets are being sold free and clear of liens, claims, encumbrances, interest, disputes, and the like, purchasers will bid more for those. Another advantage, relatedly, is that well, I'll move on to the next one, which is the process in Chapter 11 is really the best mechanism to sell larger, complex operating businesses in essentially a liquidation of the secured creditor's debt. And that's because you can obtain approval by the bankruptcy court to continue to pay employees and vendors, to obtain financing on a super priority basis, which gives all of these parties assurances. And you can also fix a lot of operational issues that a purchaser may not want to step into. So if you have collective bargaining and union issues, pension issues, environmental liabilities, if, as we're seeing nowadays, your brick and mortar lease footprint is much larger than makes sense. You can reject those leases and then deliver the assets to the purchaser. Also, another advantage, similarly, if it's a complex capital structure, those are often better addressed in court through Chapter 11 rather than through an out-of-court proceeding where some of the dissenting stakeholders could run into court and disrupt the process. And finally, as I mentioned before, a Chapter 11 case is attractive if you know that you're going to need new money financing to keep operating through the transaction, because the lenders know that they'll get all the protections of a bankruptcy court's DIP order and the associated priority that they get under that order, and they may be willing to fund you for the 60, 90, 180 days that the process will take. Okay, finally, disadvantages of a Section 363 process, and we touched on some of these. They're really, in a lot of ways, the other side of the coin here. Substantially greater costs in Chapter 11. All of the professional fees can add up. It's a highly visible process, so not only for creditors and litigants that you're already in litigation with, but also for employees, vendors, customers. They will hear about the fact that you're in bankruptcy, and you'll get calls about it. The potential for challenges to senior liens is another disadvantage, one near and dear to the hearts of senior lenders. So we talked about before, if there are unencumbered assets, if there are perfection or other collateral issues, the Chapter 11 case is a forum that has baked into it the concept of, for example, a creditors committee who will be kicking the tires on the lender's collateral package, and there's the potential for litigation over that, or at the very least a settlement with the committee. And that's my next note, which is committees will be formed in a lot of these larger cases, and they will be looking for ways to extract some value out of the transaction for their stakeholders. And finally, just to note that there is some risk if a process is not done correctly, even though if it's done well, it's a vanishingly small risk, that a secured lender can have its credit bid rights, which are really its ultimate safeguard in the liquidation of these assets, the bankruptcy court could order that those credit bid rights are limited for cause. And that's really tied to bad acts, but something that I always mention when we're thinking through how the process should be run. So that takes us through ABC sales and Section 363 sales, and I'll turn it back to Joe to close it.
Thank you for joining us today for our presentation. Align the options for the commercial lender when the workout is no longer working out. If there are any questions, please feel free to reach out to any of today's speakers. Their respective contact information is located at the end of this slide deck. Thanks again for joining us today.